रेडी, कुछ वर्ड नोट डाउन करेंगे। जो आपका क्वेश्चन है ना इसको लेके, सेक्शन को लेके, अगर सेक्शन स्टार्टिंग में आ रहा है तो स्केप होगा, अदरवाइज सेक्शन एस स्मॉल होता है जनरली। सेक्शन के अंदर कई बार 1 लिखा होता है, सेक्शन 71(1). अगर ये नंबर में लिखा हुआ है 1 2 3 तो ये ऐसे लिखा जाएगा, लेकिन अगर ये रोमन में लिखा हुआ है तो ये हमेशा स्मॉल में लिखा जाता है, रोमन में। और अगर ये ABCD बोला गया है तो भी ये कभी कैपिटल में आते हैं, स्मॉल में आते हैं, सेक्शन हो या क्लोज हो या सब सेक्शन हो, हाँ, इनके स्टार्टिंग वाले वर्ड भी स्मॉल ही रहते हैं। पर एज ए सेंटेंस के स्टार्टिंग में फर्स्ट लेटर के रूप में आएगा तो आप उसको कैपिटल बनाते हो, या फिर कोई नेम बन के आता है, ठीक है। रूल का भी ऐसा ही है, रूल भी जनरली स्मॉल होता है, लेकिन जब वो किसी के साथ बन के आता है, रूल 5 किसी के साथ आता है, जैसे कंपनीज एक्ट रूल 1971, कोई एक्स वाई जेड एग्जांपल लेते हैं, तो उस केस में वो फर्स्ट लेटर कैपिटल हो जाते हैं। रेस्पोंडेंट हमेशा स्मॉल होते हैं, ठीक है। रेस्पोंडेंट हुए, पेटिशनर हुए, ये सब स्मॉल में होते हैं, ठीक है। अब एक वर्ड यूज किया जाता है वाइवा वॉइस, VOC, वाइवा वॉइस। वाइवा वॉइस का जो मतलब है ये होता है बाई ओरल टेस्ट, मौखिक। वाइवा वॉइस में आप बनाएंगे कैसे, वाइवा वॉइस, ये वाइवा का हो गया और ये वॉइस का हो गया, वाइवा वॉइस।
स्पेलिंग है
वाइवा VIVA वॉइस, बाई ओरल टेस्ट। एक बार होता है वॉइस वर्सा, वॉइस को वी से काट देंगे, VIC, वॉइस वर्सा, ये आउटलाइन है। वॉइस को वी से काटेंगे, क्या पढ़ेंगे इसको, वॉइस वर्सा। वॉइस वर्सा क्या होता है, इन द अपोजिट वे, जो अभी भी कहा गया है उसके अपोजिट कर में बोल देने को कहते हैं वॉइस वर्सा। एक स्टेटमेंट बोला और उसका वॉइस वर्सा बोल दिया कि जो कहा गया उसको उल्टा कर लो, वो वॉइस वर्सा। डिफैक्टो, DE स्पेस देने के बाद फैक्टो, एक्चुअल, डिफैक्टो। हाँ, हाइपन भी लगा सकते हैं, बिना हाइपन पे भी डिफैक्टो। वैसे ज्यादातर डिफैक्टो विदाउट हाइपन आता है, एक बार में कहीं लगा रखा तो ठीक है, लेकिन आप जो बनाएंगे विदाउट हाइपन बनाओ, डी स्पेस फैक्टो। डिजोर, DJUR, डिजोर मतलब राइटफुल, डिजोर, डिजोर होता है राइटफुल। डिलक्स, DE स्पेस LUXE, लग्जरियस, जो कुछ को टिका हो या सामान्य से ज्यादा महंगा उसको होता है डिलक्स बोलते हैं। पारी पशु बने बताए थे आपको, पारी पशु, या अलग से बना सकते पारी पशु, PARI, पारी पशु, PASSU, विद इक्वल पेस, मतलब जो समान गति से चलता है। ठीक है, डिक्टेशन लिखेंगे, स्टार्टिंग से किलोमीटर से बोलता हूँ, फिर उसके बाद लीगल 3P से बोल देता हूँ। रेडी? Start it. A reading of the above non-speaking order
दोबारा स्टार्ट करेंगे एक बार फिर से। स्टार्ट इट। A reading of the above non-speaking order would only show the total non-application of mind by the court to the gravity of the crime, the apprehension of tampering with the evidence and threats to the life of the complainant and other witnesses given by the accused. The High Court passed the impugned order in a mechanical fashion without proper application of mind and without going into the merits and evidence on record against the accused persons. The High Court failed to see and appreciate that the respondents herein, who are the main accused numbers 1 to 3, are the masterminds behind the crime committed. The High Court has not considered the material evidence available on record against the accused, which prima facie established the criminal liability of the respondents. The High Court also failed to see that the learned sessions judge, after taking into consideration the seriousness and the gravity of the crime, convicted the accused for the crime. This part, 3 other vital factors have also been not taken note of by the High Court. They are the evidence of PWs 1, 2, 4 and 5, who are the eyewitnesses and whose testimony was amply corroborated with each other. Secondly, the identity of the accused persons during the cross-examination was also established. Thirdly, the direct evidence of the eyewitnesses was corroborated by the medical evidence, and the motive of the crime was also established. The trial court has held that there is satisfactory evidence that Rajiv Singh instigated to commit the murder, and at that point of time, and in pursuance of that common intention of the accused, they fired at the accused persons. The High Court also has not taken into account the several complaints and information reports before the trial and to the police authorities stating that the accused have killed his two sons out of six. The three accused were arrested and remanded to jail, and other accused are absconding and evading their arrest, and that one of the accused, Rajiv Singh, who is on bail, has confirmed the group of criminals and comes to the house of the appellant and gives threatening to the eyewitnesses of the said order in order to pressurize them not to pursue the criminal case against them. Learned counsel for the respondent submitted that respondent number 1 had already undergone 12 months of sentence, and respondent number 2 in special leave petition number 3316 of 2004 had already undergone 22 months of sentence, and that the respondents have a meritorious case in criminal appeal, and accordingly the High Court, while admitting the appeal, have released the respondents on bail subject to certain conditions. It is further submitted that subsequent to the grant of bail order, there is no instance on record that the respondents have misused their release on bail, and therefore there is no question of the respondents either trying to interfere with the course of justice or the attempt to tamper with the evidence. ये 500 वर्डों के साथ डिक्टेट किया गया है। क्रिमिनल मैटर का 8 नंबर है, 80 की स्पीड है। सीपी लीगल से लिखेंगे। रेडी? Started. This is an appeal by the wife against the judgment of the High Court passing a decree of divorce on a petition filed by the husband under Section 13 of the Hindu Marriage Act 1955. Briefly, the facts are that the marriage between the parties took place on 2nd November 1992 at Mumbai, where the husband resides with his parents and other family members. The wife stayed in the matrimonial home up to 2nd June 1993. In between, she had returned to her parents' house at Bhuj on a couple of occasions to join her service as a teacher in a municipal school there since prior to marriage. It is common case of the parties that on 2nd June 1993, the appellant wife left the husband's house for her parents' house at Bhuj for her first delivery. A son was born on 11th November 1993. The fact is clearly established on record that after 2nd June 1993, the appellant never returned to her husband to join him in the matrimonial home. In her evidence, the wife has said that the husband visited her off and on, stayed with her there. However, this statement has been denied by the husband. But as these statements were merely oral, the courts below have rightly not been relied upon them. The undisputable fact is that on 30th September 1996, husband sent a notice to the wife through his lawyer alleging desertion on her part and also alleging that the wife wanted that the husband should resign his job and stay with the wife in Gujarat. This was on account of the fact that the wife was in a government job as a school teacher and was earning about rupees 7,000 per month, while the husband had a private job in which he was earning only rupees 1,400 per month. The husband's case has been that because he was not making enough money while the wife was earning well, she always wanted him to stay with her there. The wife denied the allegations of the husband and stated that she was prepared to stay at Mumbai with her husband. While appearing as a witness in support of her own case, the wife has categorically maintained that she was willing to leave her job provided the husband was earning at least rupees 5,000 per month, that he could properly look after her and her son. Therefore, from the exchange of notices and the replies, only one thing emerges, that till 1996 there was no attempt on the part of wife to join her husband. Ultimately, on 31st December 1996, the husband filed a divorce petition seeking divorce on grounds of cruelty and desertion. The trial court, after recording evidence, accepted both the grounds and granted a decree of divorce. However, on an appeal filed by wife, the lower appellate court reversed the judgment of the trial court and dismissed the divorce petition filed by the husband. The husband appealed to the High Court against the said order. The High Court, by the judgment which is under challenge in this appeal, confirmed the decree of divorce granted by the trial court, but only on the ground of desertion, as the ground of cruelty was not pressed. It is apparent from the judgment of the High Court that the learned judge made various attempts to bring about a settlement between the parties but failed. This is noted by the learned judge that both the parties appear to be adamant regarding their respective stands, that is, the wife is not prepared to leave her job in Gujarat unless her husband is able to earn a handsome salary। ये 607 के आसपास वर्ड डिक्टेट किए गए हैं। 80 की स्पीड है, फ्लक्चुएशन ना के बराबर है। पीपी लीगल से आपको डिक्टेट किया गया। 8 नंबर है। दोनों सॉफ्टवेयर पर अवेलेबल है। पहले वाला मैटर भी, ये भी टाइप करेंगे आप जो अच्छा लिखा है।